Hey everybody, this is Mr. Moffman coming at you with another APGov video. We're continuing our tour through topic 1.5, focusing in on ratification of the U.S. Constitution. Previously, we started to take our tour through the Constitution in its original form, but as you recall, there was intense debate as to whether or not this new plan for government under the Constitution should become the supreme law of the land. And despite lots of promotion by the Federalists, there were many folks, the Anti-Federalists, that were nervous about this. And one of the biggest criticisms or concerns that folks had about this new plan for government was that there was no real explicit listing of protected rights that all Americans would be able to enjoy to protect us from this new national government. So there's intense debate, as to whether this should be happening. There's a rivalry going on. But what basically secures the Constitution as becoming the new law of the land, becoming ratified in all the states, is that basically a deal is going to be brokered between the Federalists and the Anti-Federalists. The Federalists will promise the Anti-Federalists that if they can get their support and get the Constitution ratified, then they would then, after that is done, then quickly amend the Constitution using the amending provision in Article 5 to list these rights that do need to be protected by name. And it really was a leap of faith, by the Anti-Federalists to go along with this, but, the deal gets done. The Constitution gets ratified, and, yes, it is, in relatively quick terms, amended to provide these basic liberties, these basic protections. And, of course, we call this collective list of the first 10 amendments to the Constitution that were designed specifically to protect these liberties and freedoms, as of course the Bill of Rights. So what we're going to be doing here in this video is just taking a quick tour through the Bill of Rights. Now note, the Bill of Rights will be added as one lump sum in 1791. So if you really think about it, after the Bill of Rights is put in, over the last 230 years, we've only added 17 amendments in the last 230 years. So it shows you that once you get the Bill of Rights out of the way, constitutional amendments are pretty few and far between, as we have seen. So that being said, let's get into the Bill of Rights. Of course, the First Amendment is the most recognizable to everybody, and it also speaks to what is assumed to be the founders' notion as to what are the most important rights for us to enjoy. And that, of course, includes freedom of speech, freedom of the press, freedom of religion, and freedom of assembly. Now, freedom of religion is mentioned first in the First Amendment, and it speaks to two things. Protection from having a formally established religion, that's the Establishment Clause, and also the protection to be able to freely practice one's faith. That's the Free Exercise Clause. The other protections of the First Amendment are mostly associated with making sure that we actually have a free and honest government. Freedom of speech, freedom of the press, freedom of assembly really all exist for the purpose of making sure that we have a fair government. The ability under the freedom of speech to criticize our governments, also through the freedom of the press, the ability to organize in political groups, that's freedom of assembly. So most of your First Amendment rights are actually done to protect political rights. Then we get to our second one on there, and that's, of course, the Second Amendment that deals with the right to bear arms. Now, of course, there's been a lot of controversy in the last 30 years as to what that language really means. They do include a provision in there about the idea being that this being tied to the idea of a well-armed militia being needed to secure a free state. There's been debate in terms of, does the right to bear arms, is that a collective right for groups like, say, the police, or is this an individual right? And we've seen in the last 15 years or so, the Supreme Court explicitly state that the right to bear arms is an individual right. The Third Amendment was very significant at the time. You can see it's near the top of the list for the founders, but of these 10 has certainly become the least applicable to our daily lives, and that's protection from quartering of troops. During colonial times, the British government would force colonists to house and feed soldiers as a cost-cutting measure. Since we've been an independent country, that has not been anything remotely close to an issue. So that's why a lot of folks don't even know Third Amendment exists. However, Fourth Amendment, pretty darn well known. This is protection from unreasonable searches and seizures. That basically gets into the idea that we do have an innate, even though you don't see the name in there, the word in there by name, there is some sort of an innate sense of privacy that we do, enjoy the ability to not have our stuff gone through by the government to try to, get us in any type of legal trouble. It does require that for any searches to be done, it needs to be done with a legal warrant, and those warrants cannot be issued arbitrarily. They have to be based upon probable cause and reasonable suspicion. So Fourth Amendment, pretty significant. Then we get into the Fifth Amendment. Fifth Amendment's pretty fun because it is kind of an interesting grab bag of different liberties that they put together here. The first is the right to due process. What this is saying is that if the government is to deny you life, liberty, or property, in other words, to fine you, to put you in prison, or even potentially, execute you, they can't do it arbitrarily. They have to do it through what's called due process. And due process are all of those legal steps, procedures, hence the term process, that have to be fulfilled in order for the government to legally be able to deny you life, liberty, or property. So, in other words, it stems everything from requiring probable cause to get a legal search warrant, to the moment of arrest, getting your Miranda rights being read to you, to making sure that you have the ability to have access to a lawyer, that you have a fair trial, and that your any consequences do not violate provisions regarding protection from cruel and unusual punishment. All of that is part of due process. We are also protected from double jeopardy. Double jeopardy is not just a fun part of a game show, but in this context, it's talking about the idea that you cannot be charged with the same crime twice. Now, we're not saying that if you are found innocent of murder, that then allows you to murder people in the future. It's talking about for the same incident, the same situation, you cannot be tried twice. Now, that's important because it then protects people from being harassed by the government, but it also puts pressure on governments to basically get one crack at convicting somebody. And that's why in many cases you don't see the government actually charge somebody with a crime, even though it may look on the surface like it's a slam dunk, because, the government has one shot at it. If they swing and miss, that's it. That's all there is to it. There is also protection from self-incrimination. In our legal system, we are not compelled to provide evidence against ourselves. It is the government's responsibility to provide evidence if they wish to deny us life, liberty, or property. So if you are in a situation where you are legally obligated to tell the truth, like, for example, you are in a courtroom or providing a deposition where you are sworn an oath to tell the truth, you can be protected from providing information that could be used against you by pleading the Fifth, just exercising your Fifth Amendment rights. Now, note, that's different than just straight up lying, because if you lie in an attempt to protect yourself from criminal evidence, then that's called perjury. That's a crime unto itself. So if giving the honest answer under oath could be evidence against you, you have a right to just exercise your Fifth Amendment rights and not respond. We also have grand jury protection. That is based on the idea that if the government is going to charge you with a crime, then, like a serious crime, then they have to bring it to a group of people at an earlier stage called the grand jury. The government has to present evidence. Now, that evidence is not to determine guilt or innocence, but it's just enough to determine whether or not there's enough evidence to merit charging somebody with a crime, meaning, providing an indictment. And if there is enough evidence to indict that person and make them go on trial, well, then that's where you get a normal trial situation. So that's another layer of protection. Once again, if there's not enough evidence to reasonably put you on trial, then people shouldn't have to go on trial. Lastly, it talks about putting limits on eminent domain authority. We have in our country the government's ability to exercise eminent domain. Eminent domain is the ability of the government to basically take over property. But note, the Fifth Amendment puts limits on that. The Fifth Amendment says that the government's eminent domain power has to be for public use. So the government can't just take land to take land. It has to be for public use. So it might be taking a farmer's land, like maybe, 80 acres or something, to build a highway. That would be for public use. But it also said in the Fifth Amendment that if you do exercise the eminent domain power as the government, you then have to compensate that person that's lost that property the fair market value. So, eminent domain is good because it prevents like a single person, like a farmer or something, kind of gumming up the works in terms of getting important infrastructure done. But at the same time, it also protects that person who's losing property by making sure they get adequately compensated for it. Sixth Amendment are your trial rights. So that's right to counsel. That means that's right to an attorney. That's now been interpreted in a modern sense to not only do you have the right to hire an attorney, you also have the right to have the government provide you an attorney if you can't afford one. You have the right to confront witnesses. That's important because we know that then we know the identities of these people. These are not secret witnesses that the government can just make up out of thin air. So in other words, you know who are the witnesses confronting you. Plus, you can provide your own witnesses in your own defense. You have a right to a speedy trial. The government cannot just initiate charges and initiate a trial and it drag on for decades. You have a right to a speedy trial. You also have a right to a jury of your peers. In other words, we don't have professional government jurors. These are everyday citizens that are, for lack of a better term, drafted into hearing cases. Seventh Amendment is also dealing with the courts. This is focusing in on the right to have a jury trial for most civil cases. A civil case is not a criminal case where the government's charging with a crime. A civil case is when someone is suing somebody for damages. So at the national level, at least under the Seventh Amendment, you have the ability to demand a jury trial. Eighth, protected from cruel and unusual punishment. Once again, the government cannot just arbitrarily give you over-the-top punishments such as crazy high fines for jaywalking and outrageous terms for bail if you've been arrested for stealing a candy bar or something. And the idea though is there's a lot of controversy with cruel and unusual punishment today because we think of the death penalty. Is the death penalty a violation of the Eighth Amendment or not? In about half the states, they feel it is, and about half the states, they don't. Ninth Amendment's pretty interesting because it talks about the idea being is that, you've got this long list of protections here, but what if there's something not mentioned on the list? Does that mean then that there's no other rights that are protected? Well, that's when the Ninth Amendment comes in. It says that just because you've got all these other rights that are mentioned by name doesn't mean that there aren't others that would be protected. There are implied rights that exist. Now, that doesn't mean that, you can just make up rights on the fly. You can only have implied rights as long as they are tied to rights that are explicit. For example, we have, even though it's not in by name, the right to privacy, we do, when you connect the Fourth Amendment to the Ninth Amendment, the courts rule we do have a right to privacy. And if we do have a right to privacy, what does that mean? Well, the courts have ruled that the right to privacy includes things such as, the right to access birth control. And until recently, it also included the right to for women to have an abortion. So we do have this idea of a right to privacy from the Ninth Amendment. In other words, other rights do exist, even though they may not be listed by name. And then lastly, you have the 10th Amendment. This is also another key protection for those that are worried about a big, strong national government. It says that any power that's not explicitly given to the federal government, like, say, raising an army, or anything that's not denied to the states, is then held by the states, or the people respectively. This is basically your states' rights protection. So, for example, when you look at public education, it's not a power that's explicitly given to the federal government by name, nor in the Constitution does it say that states can't be in charge of public education. Therefore, per the 10th Amendment, public education is a state power, and that's why we have a State of Ohio curriculum. So, all right, that's our tour through the through the Bill of Rights. So hopefully you enjoy that. We'll see you next time. Bye-bye.